Okay, we're live.
Great. We still have 0 attendees at the moment. All right, here we go. Hello, everyone. We will go live with the webinar in another 20 or 30 seconds. Just want to make sure that everyone actually gets into the room first before we start. So we'll start very shortly. Great. Okay. So good afternoon, everybody. This is our 3rd privacy question time. We started in the depths of lockdown when no one was talking to anyone. I think we were rather relieved to be able to chat online. So thank you very much for joining us. The format is not dissimilar to the famous BBC programme, which is questions are posed. We try to answer them as best as we can. There may well be a bit of disagreement and chatter amongst us, but it should be an interesting and insightful hour. You may ask questions of the panel. So if you go to the chat section on the screen, you can pose a question. And we'll endeavour to answer as many as we can in the next hour. It is a hard stop at 5 o'clock. A number of you have submitted questions already in advance, and thank you very much indeed for that. We're always very grateful when we get plenty of questions, and we certainly got plenty this time. We are recording the session as usual, and it will be available for you to view again if you wish. You should receive a link to the recording by email this time. The panel on the screen will be introduced in a minute. Let me just give you a bit of an introduction about the Data Protection Network. So for those of you who have not attended our events before, the Data Protection Network is a thought leadership and data protection consultancy. We help clients both large and small with data and privacy matters. We also publish useful articles, guides and opinion pieces alongside upcoming events on our website. So if anyone wants to look, you'll see a large volume of free materials for Data Protection Network. We also provide training workshops for teams who handle personal data, and these can be small or large. They're practical and engaging sessions, and we use relevant examples wherever possible to bring examples to life. We pride ourselves on providing practical advice and no-nonsense advice. And also we provide events like today. So our next event in December is going to be getting to grips with marketing and data protection, and that will be on December the 8th. So please look at our events page for that in the future. So just in terms of me, I'm Julia Porter. I'm a partner at Data Protection Network. I help a wide range of businesses, both large and small, with data protection matters, and the majority of them are business to consumer. I've been working in data protection for the last 10 years, both as an executive as well as a consultant. And I was one of the founding directors of Data Protection Network when it started out as a thought leadership body in 2014, actually, so 8 years ago. My executive career includes marketing director at ITV as well as The Guardian, and I was the chair of the Data and Marketing Association in the early 2000s. So now I'm just going to pass you over to Robert, who is our very able chair for the day, to introduce himself, and then we'll move on to introducing you to the rest of the panel.
Thank you, Julia, and thank you for asking me to chair this panel. I'm Robert Bond. I'm chair of the Data Protection Network. I'm senior counsel with Privacy Partnership Law, and I'm an external data protection officer for several global organizations. One is in energy, another is in insurance, and another is in entertainment. And I've been doing data protection for 39 years. So I'm now going to hand over to Fedelma to introduce herself.
Many thanks, Robert, and good afternoon, everybody. It's a pleasure to be with you. I'm not going to confess how many years I've been working in privacy. That's far too revealing, but suffice it to say, it's been a number of years. I am currently a director and co-lead of PwC's data protection advisory team here in the UK. Like Robert and Julia, my clients span a range of industry sectors, predominantly larger organizations and predominantly organizations that operate on a truly global basis. My real area of love and speciality is e-privacy. But as I say, it's a pleasure to be here this afternoon. I'm looking forward to a good conversation.
Okay, and over to you, Steve.
Thank you, Robert. My name is Steve Priestley. I work as head of UK data protection at Travelex, which is a foreign currency exchange business located around the globe. I have been working slightly less years than Robert and Fedelma in data protection, so I'm very much the newbie and junior partner to my more esteemed colleagues here.
Thank you. And we've had, as Julia said, quite a number of questions sent in advance of the webinar today. We will obviously look at questions as they come in whilst we're going through the next 55 minutes. But what we've done is we've grouped some of the questions that we've had into particular areas. And I'm just going to launch straight in here. There's a group of questions we've got here relate to marketing, not surprisingly. So I'm going to start with this question, which I'm going to put to Julia. And then by all means, Fedelma and Steve jump in. So the question I've got is, what constitutes a service email rather than a direct marketing email? Over to you, Julia.
Thank you, Robert. Good question. I seem to get asked this question all the time, and there's definitely shades of grey between service emails and marketing emails. When I talk to clients about this, I try to really simplify this and say, okay, a service email can be something that provides you with information that relates directly to the contract which you're engaged with an organization. So it could be, you know, I've booked something, here's a confirmation of that booking, here's a receipt for a booking. It could be, you know, your train's going to arrive on such and such a time. One of the kind of rules I sort of say to marketing teams, just to really simplify it, is don't put prices in and don't put offers in and discounts. And if you do that, you're largely safe. However, there are then grey areas. So I used to run a subscriptions business, and in my subs business, before the subscription had run out, we would then say to someone, this is your last copy of your subscription, and we would treat that as a service email. If you just think after the sub has run out, arguably that becomes a marketing email. So my advice is make a list of every single email you send someone and tick off, is it service, is it marketing? And then the grey ones in the middle, have a good debate about whether you can legitimately treat them as service messages.
Okay, anything to add, Fedelma?
I think just to add to Julia's really good comment there about the subs email, I think if in that subs email there was an inclusion of an indicative or inducement to resubscribe, or if you resubscribe now, we will give you an increased discount. You know, as she says, anything that gets close to pricing definitely would be considered in the marketing space. So it's that straightforward, informative service email that the individual needs to actually use and gain the benefits from the product or service that they've already contracted to buy from you. It's those guardrails then help.
Yeah, and Steve, any other thoughts?
Yeah, no, agree with that totally. The only other thoughts I've had is that in terms of ICO enforcement, quite a few of them have been with very, very low complaint figures. So I think one of them was only initiated by one single complaint. So you can see you can run quite a high risk with those grey areas that you were mentioning.
Yeah, and you know, over the last few years, we have seen, haven't we, the ICO taking action against organisations that have pretended it was a service message when in fact it was an attempt to do further marketing or preference setting, etc., etc. Okay.
Exactly.
Sorry, Robert, you just triggered another thought in my mind there. One of the things I think that has caught people out previously is exactly that point that you've made, which is when I have opted out of marketing, can you recontact me just to check, if if that is what I wanted to do, because that in itself is not a service, that is that constitutes marketing in its own right. So I think it is guidance and care around those areas of trying to re-encourage people to opt back in.
And actually, as we've just been talking, I see there's one or two comments and questions coming in. And as I'm going to pick one of them here. If it's a renewal notice, it would probably include a renewal price. So,
yeah,
is that a service message? But in tilt,
I'd say not. If it's got an offer in it. So what we would highlight the fact that subscription was ending, but there would not be an offer in it. I think it's when you have an offer, it's when you're straying into dangerous territory. I had an interesting example, actually. This morning, in fact, I was talking to a very large retailer who was running a loyalty scheme. And actually, part of the loyalty scheme was they have a card. And every time they buy something in the shop, they generate rewards in discounts. And actually, when they sign up for the card, the sign up says, you're signing up for this card and we will email you these rewards, discounts. So actually, that's the basis on which people signed up, expecting to be emailed these rewards. But they then were having a discussion with their legal team, who were arguing that emailing those rewards was a marketing message, even though by signing up, they were expecting to receive those rewards. So sometimes I think you can be a bit overzealous with the marketing versus service message piece, because in the end, I concluded with the client that actually, this was part of the service. This wasn't a marketing exercise. Again, you have to be very careful about the fact that you don't have offers in there. But actually, if you're just saying, here are your vouchers, that's just fulfilling part of the deal.
So is that the similar approach? Because we've had another question about what if a local authority who wants to make residents or tenants aware of services they could benefit from, would a communication about those benefits be service or marketing?
Depends what the services were and whether you had to pay for them or not, I suppose.
Yeah. Okay. On the just shifting for a second, and thank you to everybody who is sending the messages and questions in. Turning to Pekka, we've got a specific one here. Fedelma, I'll ask you, are charities included in the soft opt-in marketing? Is it only allowed for charity shops where products are sold?
Blimey. Julia, I might go to you while my brain gets into gear on that one.
So I'm a trustee of a charity, actually, and we have talked about this quite a lot, because if actually you have a charity shop and you could use that, you could use soft opt-in if you're buying stuff from the charity shop, but then you can't necessarily use that permission in order to then do fundraising, because you still need consent for fundraising. So the debate then is, if you've got a charity that has a lot of shops, it's in your Separate Heart Foundation, maybe an example of that, which has a large network of shops. They want to collect data in order to promote their shops because it's a large part of their business. But actually what you need to be careful about is you can't then use that data for donations and fundraising.
And it might be worth us remembering what the conditions for the soft opt-in are. And they are very clearly that you provide the individual with the opportunity to opt out at the point at which they provide their data, that the marketing will be for related similar products and services. So Julie's example there of the charity shop versus their fundraising would be those two different elements. And the third is that they don't opt out at the point at which the consent option is given.
Okay.
Or sorry, the opt-out is given.
Yep. And
well, I guess the other point to make here is that if the new bill does go through as currently drafted, then the soft opt-in will be extended to fundraising for charities. So that's what was in the consultation. Who knows what will kind of become law? But I think certainly from my perspective as trustee of a charity, that's good news. I'm quite pleased about that.
That would make sense.
Yeah, and of course the other group that is included in that is political parties. Yeah. Sorry, we're laughing, but yeah, so that is included in the bill as well.
Yeah.
Yep. We've got another question here still related to marketing. And this is probably the last one we'll do on marketing itself, but it happens to be from a charity that is doing a lot of different activities with personal data. And the question says, we're finding it difficult to manage different preferences. For example, our supporters might not want to receive general marketing, but will be happy to receive specific fundraising event communications. How do you technically manage preferences? And frankly, this is something that we have to address in all sorts of businesses. But I don't know, Steve, do you want to start with that one?
Yeah, it really just depends on what technology, if any, you're using. If you're using no technology at all, then it's going to be incredibly difficult to segment those customers into different categories. If you have a quite well sophisticated CRM system or as such, then that becomes a lot easier to build those segmented profiles of customers. It's so you can send them different types of communications based on their consent to what they want to receive. Obviously, the more granular as well you make those different communications choices, the more you're going to have different levels of that you're going to have to manage as well with what communications they have opted into receiving. So, yeah, it's really about looking around in the market. I can't really comment on different types of suppliers, but the one we use, we're able to effectively do that. If you're a charity, that might be quite an investment that you have to look at, but it's just something that you have to manage. Yeah,
and Julia, in your experience, are you finding more organizations are creating preference centers so that the customer takes control?
Yes, I mean, I think there's a couple of points to make here. First of all, having a myriad of preferences isn't necessarily a good thing, because you're providing a lot of complexity for the client customer to worry about. And obviously it depends on the size of the charity. So I think it's very important to actually set a small number of different preferences. The second point is that whoever you're using as your email service provider, in lots of instances, particularly if it's outsourced, you can manage a preference center via them. There's at least 2 email service providing companies I know who will provide preference centers as part of the service, and that makes it a pretty inexpensive way of doing things. Obviously, there's lots of these privacy portals who will do all of that kind of stuff for you as well, but it doesn't necessarily have to be expensive. I do think it's worth finding a supplier that you can work with where you can keep these preferences online. Otherwise, I think it is a world of pain managing to do it via workarounds. I mean, it's not clear what your workarounds might be, but I would say try and find something online, because what you ideally want is for people to be able to update their preferences themselves, rather than you having to update it on their behalf. That's the kind of nirvana.
Yeah.
Okay.
Great.
And Robert, from my perspective, I think there's two additional elements here. There is a temptation for people to go very, very granular on the choices they give people, which can sometimes actually be a step you would fall foul of, particularly if your charity is going to evolve. So it is worth just thinking right at the outset what it is you anticipate, doing in terms of the communication with your customers, your donors, if we call them that. The other element is that it has been proven that actually it is quite often the frequency of marketing that causes people to opt out. So I would encourage people to look at that control alongside the choices they give people, so that they don't sort of shoot themselves in the foot in the volume of activity when they've done a great job in giving people that sense of trust and transparency and choice over the communications they receive.
Okay, thank you. Questions are coming in fast into the Q&A box, and there's one here that is, I'm going to take it now. The question is, we use a third-party provider to host an e-tendering portal for prospective suppliers to bid for contracts. The portal is branded for our organisation, but the login page doesn't have a privacy notice or cookie notice on it. Should the portal have a link to our privacy notice or to the portal provider's privacy notice? And should there also be a cookie statement on there? And is that our cookie statement or the provider's? Sorry for the long question, Peter says. Julia.
Well, I guess it kind of depends on who's using the data for what. So if this is a portal that is a data processor and you're the data controller and you're collecting the data and they're not doing anything with the data, then arguably it should be your privacy notice and cookie notice there. I guess the question is, are cookies being dropped? Do you actually need to discuss what those cookies are and how are you processing that data, or whether there's something within the tender contract where you explain how the data is going to be processed, and then then they kind of sign up to it as part of the tendering process. And of course, the other thing is that presumably this is a B2B environment rather than a B2C environment. So obviously there are differences there around legitimate interest versus consent. So there's a few kind of maybes and what ifs that you might want to ask. But if you're controlling the data, certainly within your tender document, you'd expect something around how you're planning to process the data and how long you're going to keep it for.
Yeah, and actually part of the question also, clearly they've asked the third-party provider and they say we only use session cookies when somebody is accessing the platform. But for transparency purposes, you would still need to have a statement that says what the minimum is that's being used, which would appear to be strictly necessary.
Yeah.
I mean, all things being equal, it's good to have a notice anyway, just to explain what it is. Lots of businesses have not done so in the past. I'd say these days it's quite unusual to find websites that have nothing at all. So yeah, you're right. Yeah. Even just saying we don't have any non-essential cookies, that would be good.
And from the description, Robert, it sounds like it might be a portal which is providing the same service to a number of businesses, in which case I would expect the cookie notice to be the provider of the website and the service. And I would also expect then there to be a contract between the two entities, and that those contracts would include the appropriate data protection provisions, and that as Julia says, if it's a controller processor relationship, there would need to be clarity over what the processor is doing with data captured for the company that Peter works for. If it's aggregated in a database and the processor is doing any analytics or anything on that personal data component of it, then there could be other issues to consider.
Okay, I'm just gonna turn to Steve for the next question. So again, whilst we were talking about marketing or service messages, several people were saying, oh, wouldn't you be relying on legitimate interest as the means for communicating some of these services, etc.? So sort of getting away from PECA and looking more towards GDPR. And one of the interesting questions that we've had in advance is around when you're doing your balancing test for legitimate interests and you're trying to work out if it is a legitimate interest to do marketing to clients, what's a reasonable period for which you might rely on marketing, or reasonable expectation, or period of relationship? And the question is 10 years a legitimate interest period for marketing? Is that reasonable? If not, what would be?
Yeah. Well, yeah, it's. I think 10 years to begin with is far too long. I think most people would, but then, like you say, it could be a context of extremely long-term relationships with customers. I can't think off the top of my head exactly what that would be, but it certainly seems very extreme in most modern businesses to have that sort of length of relationship with individual customers where they actually still want to hear from you or still using your service. So for me, again, I think 2 years is reasonable. That may not be what everyone thinks that times should be applied to. But, if you do have no interaction with that person within that 2 year space, then quite frankly, they're probably not going to be transacting with you or be a relevant customer.
Okay. I'm gonna move on because I'm noticing we're getting towards the half hour. There's a whole series of questions on DSARs, and I think many of us are seeing a more weaponized approach to the use of DSARs and so on. So one of the questions we've got is, and this is taking into account something that was an early discussion point for the new bill, is do you think it's reasonable to move back to being able to charge a fee to reply to a DSAR? What do you think, Fedelma?
I think for certain businesses it certainly is, but I also think for some businesses equally, it isn't. And I know that's sitting on the fence in a fairly political answer. One of the things I think in the context of DSARs that I have found slightly surprising is the extent to which technology is being used as a reasonable means for supporting them. And secondly, that the approach and engagement with the individual submitting the requests has not yet moved on. But let me qualify why I think for some businesses it is appropriate. Again, we're seeing an increase in the third parties facilitating this approach for individuals, and sometimes that is being done as a weaponized approach to impact a particular business. And I think businesses have to be able to actually defend their operational processes, and in those instances it should be reasonable. The identity of vexatious or challenging DSARs is in itself a challenge, but in practice and in practical terms, I do agree with this, and I think it will hopefully bring a balanced approach. But my encouragement would be to businesses to look for the facility for individuals to look at the individual the organization holds on them easily and quickly through digital channels.
Okay, good point. Good point. Steve, what do you think?
Yeah, I agree completely with that, with those points as well. I think it's an incredible challenge for some businesses to have to manage these requests. A nominal fee may persuade some people who are just putting in sort of speculative requests in to not do that, and that actually may free up people who actually genuinely want access to their information to pursue that. As Fedelma said, having those technology in place to almost have a self-serve function where you can actually go in and extract the data or view the data, etc. Have access to that data is the way forward. But obviously, the resources aren't there for every business to be able to do that. But I think in principle, yes, it would be a good thing to introduce that nominal fee.
And Julia?
Pretty much in agreement with Fedelma and Steve. The only reason not to is some people have argued that vulnerable individuals can't necessarily afford to pay a fee. But having said that, I think the counterpoint, particularly in terms of deterring the kind of bulk DSAR requesters, would be a good thing. And if the disgruntled employee is going to ask for their information, they're going to ask for their information anyway. It's step one down a tribunal route anyway. So hopefully it would get rid of some of the kind of really annoying, time-consuming requests.
Do you know? Sorry.
Let me just jump in there, because I, from the chair, take a slightly different view, which is that I'm not sure that a nominal fee would make that much difference at all, particularly to the weaponized attacks. Because where I think we're heading now is, and this is another question that's come in, is at what point do you take the view that these third-party portals and these weaponized attacks are not actually genuine data subject requests at all? They are vexatious. They're an attempt to make life difficult for business. And I'm certainly seeing out there right now law firms for high-profile clients using DSARs and the related other rights to simply grind a business into the ground in parallel with all sorts of other, court actions and so on. Isn't there a point at which you're entitled to say as a business, enough is enough? I am not responding to yet another request for precisely the same as you've asked over the last 6 months.
And do you think, Robert,
on,
in that context, though, do you think that if there was a nominal fee, that the process of having to gather that fee would in itself deter these bodies from actually undertaking the process? Because they would have to actually go through the process of gathering that sum and paying it. So for me in itself, the other thing that struck me though is that in the pre-pandemic world, that fee was typically paid by a check. Now, I don't know if any of you've looked at the process of paying a check in or multiple checks in now, but our banking environment has moved on so far now that paying by check would certainly be both, it would be problematic for businesses, which means that any business that is looking to put something in place to take payment for a DSAR would actually have to be able to take probably a digital payment process. And that in itself could impose restrictions on businesses and hence on individuals with their ability to execute their request for a DSAR. So I do think that there are going to be some environmental issues that would have to be addressed if the nominal fee is reintroduced.
And having said that, any DWP applicant has to be able to do things online these days. So it feels like the world is being pushed, potentially unfairly, towards doing things digitally anyway.
So it's not, well, it is about the individual, but it's also about the business. Because if you think about how businesses at the moment will take a request for a DSAR, yeah, they would have to adopt those to take a payment.
Yeah, it's true.
Okay, good. I'm just looking at some of the other questions. Earlier, we've all said that businesses should put in place a solution so that you can categorize permissions and the who, what, when, where, why, and how of what you're doing with people's data, which leads me on to a question we've had about what's the most effective way of managing a record of processing activities without technology? Is that feasible, Julia?
Well, yes. I'm going to assume, for the sake of my point, that an Excel spreadsheet is not technology and that people can use a spreadsheet. Because I think without a spreadsheet, it does become unbelievably problematic. But in the end, record of processing activity is very much about getting the organisation to share with the privacy team or the legal team what exactly they're doing, and whether you do or do not have technology is essentially beside the point, because the kind of step one is going around the business and finding out what people do, understanding how they can how they process that data, and then encouraging the team to share with you exactly what they do. So we have quite a lot of ROPA projects at DPN, and we get invited to help because the people in the centre find it difficult to encourage individuals to share what's going on. So actually, our steps really is find the kind of big blocks of activity, probably go through a fairly boring interviewing process with some form of questionnaire, get that filled in, use this Excel spreadsheet. If you've got SharePoint or something like that, I guess that's potentially a bit of additional technology. If you have your spreadsheet with links in that to folders in SharePoint, that's pretty low tech and doesn't really cost a great deal. Most organizations will have either Google Docs or SharePoint as part of their email provider. And that's a pretty low tech approach and works fine. Otherwise, you move into paying fees to these larger providers. But, you know, a number of our clients actively do not go down that route just simply because it's a sledgehammer cracking a nut.
Okay. Any comments, Steve?
No, just the same, really. I just agree. It's about having those conversations with those functions and those head of functions to find out exactly what they're processing. I think the big challenge is actually keeping it up to date as well, because of the fast changing nature of businesses and what they're doing, etc., and what their processing changes, etc. New vendors, you know, we're talking about vendor due diligence as well, and onboarding new vendors and things like that. It's almost a very huge challenge to keep those ROPAs up to date, and I think that's, you know, that's where perhaps technology can have a greater influence as well.
Okay.
Yeah, I think, Robert, that Julia and Steve there have hit the nail on the head, that actually it's the process of engagement with individuals, and that's where we find the actual clarity of roles and responsibilities in an organization, because it's not getting your ROPA in the first instance, it's keeping it up to date, as Steve says, is the biggest challenge. And one of the points that has been proven time and again is that if an organization has a breach, having an up-to-date and accurate ROPA can be one of the best tools you have to actually understanding the impact and helping control any subsequent issues that you are dealing with as a result.
Yeah, and I would say also that having an up-to-date ROPA would put you in a better position to respond to an aggressive subject request, because it ought to be guiding you as to what was the ground you relied upon when you collected that data, because individuals believe that subject rights are absolute, and we know they are not. And so they, you know, if the ROPA can map when you got the data and why you got it, you may be in a position to say, no, we won't erase your data because there is some other legal obligation that made us collect your proof of identity, etc., etc. So I think it's the ROPA is so central, and I'm disappointed if we find that that's going to be replaced by the bill.
Couldn't agree with you more. That's one of the big surprises. Yeah.
Just changing tack for 1 second and making this a little more personal to you. One of the questions we had is, what's the most difficult job you've had to do when working on data protection issues, and what lessons were learned? I'm going to start with Julia on this one.
Well, I can think of two, actually. So firstly, if there is an ICO investigation, then your life grinds to a halt whilst you spend an inordinate amount of time having everything combed through in minute detail. And they won't just look at the thing that they started with, they'll look at absolutely everything. So you could end up getting into a spot of bother over something that you thought was perfectly fine. So that, you don't want that. That's a world of pain. But the second thing is about, so I'm a marketer, so I can say this as a marketer, is a data protection person speaking to a marketing team and trying to encourage them to be compliant in their activities, because you get an awful lot of disbelief and surely we don't have to do that, really. And so that's when your kind of persuasion, leadership skills kind of come into play, is to explain from a pragmatic point of view why it is that you need to do these things, and actually then moving away from the laws and the recitals, which makes marketers turn off, into very practical, what do I need to do next? Language is so important.
Yeah, and Fedelma.
Well, I'm casting my mind back a number of years when I was early in my hands-on experience of dealing with privacy issues, and to a similar vein as Julia, we got a request in for clarification from the ICO on something. So the biggest lesson I learned from that process was, one, don't panic, and two, don't forget the ICO actually are a very approachable regulator. And what I failed to do was just validate with them exactly what they needed. And actually the process we undertook to, gather documentation, check the processes, was far above what the actual ICO need was. So my lesson was read, but also be prepared to engage with the regulator or whoever is asking the question. It's the same with, a data subject. If they have a complaint or a query, quite often a process of engagement and dialogue will simplify the process. So that for me was a very painful but very, very, very valuable life lesson. Just validate that you really understand what is being asked and be prepared to check. Quite often you will be happily surprised with the outcome.
Thank you, Fedelma. Steve.
Thanks. And for me, on a personal note, moving from a non-legal and compliance background into a career in data privacy was a big challenge for me, and sort of learning all this new terminology and being able to apply that quite quickly to a range of different stakeholders. But on another anecdote I have is I manage the third-party vendor due diligence here at Travelex, and one of our vendors once answered a question on how they completed DPIAs by saying that they kept them as small as possible. So I had to go back to them on that one. So I think one of the challenges is trying to extract the information from a range of different people. You sometimes play detective, and that's a big challenge in itself as well.
Yeah. Okay. Thank you.
Robert,
we've got one. Yes.
What was yours?
Oh, have you got time? So I think, well, when Christopher Graham as ICO got the increased power to fine up to, I think it was £500,000, in my law firm, asked the marketing department to help me put a mailing together to our most important clients, alerting them to this change in the power of enforcement and fines. And they said they were too busy organising a polo match. And I could it wait till next week? And I said, no, it's got to go out today. Look, just give me the spreadsheet for our most important clients and I'll do the marketing stuff myself. So I created a very good mail shot. I added a picture I'd taken of the scales of justice, did it on my Mac. It made it about 15 or 20 meg, and I attached it to an email that said ICO gets powers to fine for data breaches up to 500,000. And then said, excuse the impersonal nature of this email, but I wanted to let you all know about this. For further information, email me at. And I attached my wonderful 20 meg document. I know, because I'm a clever person, that you put everybody in the BCC box, so I did. But when I pressed send, it started egg timing because it was so heavy. And then IT rang me up and said, what on earth are you trying to send out through the system? This was in August. And I said, don't worry, I'll just Control-Alt-Delete and I'll zip it. So I zipped it and I resent it. I didn't check what I'd sent, but unfortunately everybody had dropped into the 2 box. And whoosh, off it went into the ether, followed several minutes later by Mr. Angry from Isleworth saying, who are you to share my personal email address with all these other people? I'm going to report them to the ICO. I started to slink down in my chair, and then I got a phone call from the ICO himself because he was also on our most important list. And then I got a call from Peter Fleischer at Google, who said, if anybody tells you off, we've all made a mistake. My mistake was trying to be a marketer. I should have left it to the marketing people, stuck at being a privacy lawyer, but there we go. Anyway, moving on from that, there's several related questions that have come in about the ICO's focus on purchase data and complaints from individuals. Do you think that's changed our attitudes to the way in which we do due diligence with brokers, with sellers? What do you think, Steve?
I don't think it should change the level of due diligence you do on buying in any lists. You should always do the checks that were done, as historically anyway, to check, the validity of the of where that data has come from, whether the transparency requirements, whether you're listed as someone who they were going to be sharing the data with, all of those sorts of things. I don't think the approach should change at all.
Okay, Fedelma.
Robert, apologies. You broke up for me as you were asking that question. Would you mind just repeating it?
Yeah, it was, do you think that the ICO's focus on, use of third party, or rather buying in data and blanket emailing, do you think that we need to do more due diligence on the brokers that sell us marketing lists?
So I think Steve has covered that. I think it is absolutely essential that every organization that is acquiring data, regardless of the source, actually validates that source and is very, very comfortable that it has been gathered in compliance with the provisions of the law. I think it is far too easy to accept a word of mouth assurance that isn't sufficient anymore. And in my view, it's absolutely essential that you reassure yourself, both in word and in fact, about the origins, the recency, the frequency, and seek evidence from that third party. It is your brand that is being impacted, and it's your brand that you should be protecting in that context.
Okay. Conch, keeping an eye on the time. We've got 1 or 2 questions that came in advance, and I've seen several coming in as we've been talking, about international data transfers. There's a question which I think I've certainly seen this issue in practice. As we start to address international transfers and we're using the new SCCs, we're attaching data processing addendums to contracts. The question is, do those DPAs and SCCs need to be signed themselves, or does the overriding agreement signature suffice? And I'm going to go back to Fedelma on this. What are you seeing with what is being put together in your work?
So in our world, what we are seeing is that it is needing that clear signature and agreement. Yeah, in that context, I think what is absolutely imperative here is a clear understanding, yeah, on both party sides as to what is being requested and accepted in terms of the contractual terms. I think given the focus that we have had, that anything that indicates perhaps not that clear acceptance on behalf of the signatory, as it were, could in itself prove challenging. So we're seeing sort of the latter of what you described.
Okay. And several people have said, sent in questions about AI, and obviously it is a hot topic right now. One particular question, Julia, is what are the privacy implications of using personal data for training an AI model?
So there's been quite a lot of debate about this because AI largely is machine learning at the moment. So using historic data in order to understand patterns and trends for the future. And because the past doesn't necessarily or should not necessarily be a predictor for the future, then the data that you put into that model in the first place would have a fairly significant influence on what the output is in the future. So if I'll give you one dodgy example, a very large tech company had an AI model which was about sifting applications for jobs for engineering roles. And the AI model they built, which is based on historic data, spat out responses which were all men. So they basically filtered out all the women and just had men. And that was because in the past, all of the people have been men. So there is a very legitimate argument about using personal data in order to build a balanced model, in order to remove bias and discrimination. And one of the arguments that took place through the consultation process with the government was about, you know, whether you should use legitimate interest to use that data rather than consent. There's all sorts of valid reasons why you should use that data, but actually one of the other arguments is if you do use that data in order to train the model, and that's a good thing to do, you need to kind of keep the model updated and train it on a regular basis, but also once you've used that data, you should get rid of it. And so you don't want any data kind of hanging around. So that's kind of one point. And then there's a general point about AI. And you get this an awful lot from tech teams who say, it's a black box. We can't tell you how that model's working. You know, don't ask us questions. And that's simply not good enough. Like there should be a clear governance process around how you build these models and how you manage these models. And there should be certainly some human voice in that mix who is able to ask the awkward questions about how those models are built, because there's real danger of affecting vulnerable individuals by bias and discrimination being introduced, and you don't even know it's there.
And I suppose it's a classic for we need to have done a DPIA, we need to work out how we manage privacy by design and all of that stuff.
Absolutely. I mean, the ICO says the DPIA should be absolutely essential. So what you often see, though, are these models have been built and none of that governance exists at all. You've got some large organizations who are starting to do that now. And in fact, I did a training session with a very large pension provider who was starting to think about that. But actually, you should have a governance framework around it, and you should make sure that you ask awkward questions about it, and it shouldn't just be something that sits within the technology team.
Good. Agree. Yep. Steve, did you want to add anything to that?
All I was going to say is that quite often a shortcut is to sort of buy in a third-party vendor's AI, and obviously it goes back into that sort of due diligence again on really looking at exactly what they're doing, and what the outcomes are as well of what they're proposing that this AI model will do. So it's not just taking their word for it, but actually really digging in deep and understanding what they're saying that the AI model can do for the business, rather than just developing it yourselves. So
Okay.
And
So, yes,
sorry,
Fedelma.
Robert, I was just going to say one of the things for me in the context of those AI models and the learning and the evolving models is the ability to actually evidence the data that was used at the point that a decision was made that impacts an individual. And for so many of the solutions now, that is not a possibility. So what you have is an outcome without evidence of the decision making and the data that was used to make the decision that gave the outcome. And
Good.
I think that's problematic.
Yeah.
Okay. So actually, while I've got you, Fedelma, there's a couple of questions before we come. Life risks keep you awake at night for your organization or your clients' organizations. Do you think there are any, is there a specific area you'd recommend organizations focus on right now?
Well, right now it's the cross-border data transfer issue, given that we're coming to the end of or coming close to the deadline for that. And the second area for me is in relation to cookies and tracking technology. I think we are still early in the understanding within organizations about the extent to which tracking technology is actually in use by the organization. And as we move into more and more development in the Internet of Things, I think people need to be open to the fact and aware of the fact that those IoT devices in themselves may constitute a device as defined under the law, and organizations need to be very, very aware of that as they look to take advantage of data gathered through those new Internet of Things technologies.
And Julia, same question to you.
Cyber attacks and data breaches really worry me a lot. I sit on a board of a business that was attacked earlier this year, and it was fantastically disruptive. And the amount of energy and effort required to kind of get the business back up and running was huge. But we had done a fair amount of preparatory work, which is worth it. So my thoughts to any organization who thinks they've got work outstanding, just get on with it and do it. It has a huge impact on the business. It can put people out of business. It can be that bad.
Okay, and the same to you, Steve.
I think it's just those unknown unknowns. So it's just the things you worry about that you don't know. It's trying to keep a lid on, trying to keep a broad lid on everything that is occurring within an organisation or within your partners' organisations, etc. Businesses move at such a pace. With resources that you have available, it's trying to manage all of those work streams, all of those projects and programs. So I think that's probably the key one.
Okay, and just as we sort of close out towards the end, I'm going to ask each of you what your thoughts are, or what you understand is the sense of direction for our data protection and digital information bill, if that's what it's still going to be called. Fedelma?
So my understanding at this point is that despite some communications to the contrary, that there won't be a public consultation, but that DCMS do want to continue to engage with UK businesses, and that any engagement that they may have with businesses about the content of the bill won't delay the passage of the bill through Parliament, which will recommence with its second reading. But the exact timetable is yet to be determined.
Okay. And Steve, anything else that you've heard about the bill?
Nothing that Fedelma hasn't mentioned. No, I've just been following it like everyone else through its ups and downs. And yeah, I'm keen to understand what transpires next. But yeah, nothing further to add from me.
And from you, Julia?
So we just need to get on with it as soon as we can, really. I mean, having gone through that very detailed consultation process and actually come out with something that broadly I thought was pretty decent. We want to make sure that we retain that business-friendly focus, but most important of all, retain adequacy as well, because no adequacy would be a nightmare. So just on that note, I'd just like to thank everyone for joining us today. We've just hit 5 o'clock. So thank you, Robert, for being a brilliant chair, as always, and also to Fedelma and Steve for participating a little bit blind, really, because who knows what people are going to ask. And also very much to our audience for participating and asking us many questions and for showing up. And we look forward to seeing you on December the 8th. So thank you very much and goodbye.
Bye.